Is it possible to go through an entire pretrial deposition and not have a single objection to my opponent's questions of my client? Would you like to know the answer? Come join me on this walk near the beach as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. The answer is most unlikely. Now, why do I say that? Well, yesterday I did a deposition, which means that my client was questioned by 3 different lawyers. And the purpose of this questioning was to find out from my client what happened, in his own words, to learn from my client what problems he has today, and to learn what injuries and limitations he has as a result of whatever occurred. Now, during the course of questioning by the defense attorneys, if I don't think that a question is appropriately asked, in other words, that it's not phrased appropriately, in fact, I have an obligation to say, objection, that's improper, or objection, that's not relevant, or objection to form. There are many, many different types of objections that I can raise during the course of questioning of my client. Now, if I don't think that a question is appropriate, does my client still have to answer that question? In 99 times out of 100, that's 99%, the answer is yes. If, however, the question is so palpably improper, so off the wall crazy, having nothing whatsoever to do with the claims or the defenses in this case, then I would say that no, my client does not have to answer that question. What about if my client is asked questions about what he and I talked about? In that instance, I'm going to yell out, objection, that's privilege and confidential, counselor, and you know better than that. In that instance, my client will not have to answer that particular question. So now, let's go back to the question I raised in the title of this video. Is there ever an instance where defense lawyers are going to be questioning my client in a medical malpractice case, in an accident case, in a wrongful death case, and now I don't have a single objection throughout the entire questioning, throughout the hours and hours of questioning? It is possible, but I will tell you, in doing this more than 34 years, I don't think that's ever happened. I don't think that's ever happened to me or one of my clients. Now, the deposition that I was involved in yesterday came close. And why do I say that? Because the attorneys were there to question my client solely about damages. What injuries, what problems, what limitations, what disabilities did my client have? There was no issue whatsoever about who caused the incident, who caused the malpractice. Okay, that was not part of this deposition. Instead, the only thing that the attorneys were there to do was to learn from my client what problems, what medical care and treatment he received, what services he received, and what things he could no longer do that he was able to do before. Each of the attorneys who questioned my client were professional. Each of the attorneys were experienced. Each of the lawyers did what they were supposed to do. Now, there were a few instances where the question was asked and I did not like the way that it was phrased. In that instance, I said, objection, please rephrase your question, which means I'm not stopping the attorney from asking my client about this particular topic. Instead, what I'm doing is I'm alerting the attorney to the fact that I don't believe that his question or her question was appropriately phrased and that it might have multiple meanings. If they answer yes, it could be a compound question where the yes might refer to the second part of the question but not the first, or the other way around. So in order to prevent uncertainty down the road when somebody reads that transcript, which is what happens with these pretrial depositions, there's a court stenographer there to record all of the questions that are asked and all of the answers that are given. And by the way, you should know that the answers that are given represent my client's sworn testimony. They swear to tell the truth. And that carries the same exact weight as if they're testifying in court, in front of a judge, in front of a jury at the time of trial. So these defense lawyers yesterday did a great job. I have to give it to them. They did a great job of asking my client questions. And only a handful of times did I have to ask the various attorneys to simply rephrase 1 or 2 questions or another couple of questions. Why? Because I didn't think it was appropriate the way they asked it. And you know what they did? They gladly re-asked the question a different way, and now my client was able to answer it, and I no longer had an objection, which is exactly how things are supposed to happen. Unlike other lawyers, often inexperienced, who are reading from a script of questions that they believe that they have to ask, even though, in my opinion, it's not even remotely related to the claims or the damages we're claiming in the case. But now, some of these attorneys ask a question, and when I object to the question, they dig their heels in and start arguing with me about the question. I asked that question, I want an answer to my question. Really? Well, why don't you ask it a different way and you'll get the answer you're looking for? Nope, I like the question the way I asked it, and I'm not going to change my question for you or anybody. Great. Well, if that's how you're going to be, my client is not going to answer that question because it's an inappropriate question. And I'm always fascinated when the young attorney starts to argue with me about how they're entitled to get an answer to their question. Instead, a smart attorney turns around and says, you know what? Okay, the attorney doesn't like the way I asked this question. Let me ask it 5 different ways. You know what? Let me ask it 10 different ways. He still doesn't like it? Great. I'll ask it 15 different ways. That's the smart attorney. Someone who takes a topic, and maybe I have an objection to a particular question. Great. Now ask it a different way. Ask it a different way. Most instances, I'm going to allow my client to answer if you clean up the question, if you rephrase it, and now you no longer have that problem. So why do I share this quick information with you? I share it with you just to give you a quick insight into what really happens in these medical malpractice cases, these accident cases, and wrongful death cases in the state of New York. You know, I realize you're likely watching this video because you have questions or concerns about your own matter. Well, if you have not yet started a lawsuit and your matter happened in New York, and you're considering bringing a lawsuit, but still haven't done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.